All right, let's dive into no-fault evictions in California. It looks like things have gotten a lot more interesting in this area thanks to SB 567. We've got some recent legal guides and case files here.
Yeah, this new legislation has really shaken things up, especially for attorneys who specialize in tenant eviction cases. We need to make sure we're ready to navigate all these changes, so we can advocate effectively for our clients.
Absolutely. So let's use this deep dive to really break down exactly what a no-fault eviction is in California. And how SB 567 has changed things, and also what legal strategies are emerging in response to this new law.
Sounds good. It's important to remember that California law still allows landlords to evict tenants without them doing anything wrong, even with these new changes from SB 567.
Okay, so a tenant can be evicted even if they pay rent on time and follow all the rules.
Unfortunately, yes. There are specific situations where landlords can end a tenancy, even if the tenant isn't at fault. Genuine Property Management, which is a property management company in Orange County, explains some of those common reasons in their guide. Reasons like the owner moving back in, or a family member needing the unit, maybe taking the property off the rental market entirely, or even doing major renovations.
That major renovation reason, that seems like it could be abused. How has SB 567 impacted that particular justification for no-fault evictions?
It's definitely one of the areas where SB 567 has had a really big impact. Before, landlords didn't have to give much justification for saying a renovation was the reason for the eviction. Now they have to give detailed documentation about the work, including permits and plans.
So landlords can't just slap on some fresh paint anymore and call it a day.
Exactly. They really need to have the evidence back up their claims now. And there's another interesting change, too. SB 567 gives tenants the right to move back into the property after those renovations are finished if they want to.
Wow, that's a big shift.
Yeah.
Do you see that right of reoccupation being exercised a lot? What kind of legal considerations come up there?
It's still relatively new, so it'll be interesting to see how it all works in practice. There are definitely some potential issues for both landlords and tenants, like what if the rent has gone up significantly after the renovation? Can the tenant still move back in at the original rent? These are questions we will probably see litigated over the next few years.
So SB 567 is creating some interesting legal challenges, especially around these renovations as a justification for eviction. Are there any other areas where you see this law having a big impact?
Another big one is the owner move-in justification. SB 567 tightened up the definition of who's considered an owner or family member for this purpose. It's not just anyone the landlord says is family anymore.
Interesting. So landlords can't just say a distant relative needs the unit and then rent it out to someone else at a higher price.
Yeah, that's what the laws is designed to prevent. Now, the owner, or that qualifying family member, has to actually move into the property within 90 days of the tenant leaving and live there for at least a year.
It seems like SB 567 is trying to close those loopholes and create a more level playing field. But it also sounds like it's created a lot of new questions and gray areas in the law.
Absolutely. We're already seeing a lot of debate and litigation about how to interpret and put this new law into practice. And it's really important that as tenant rights attorneys, we stay on top of these changes. We need to understand how SB 567 is being applied by the courts.
So for attorneys like yourself who are on the front lines advocating for tenants who are facing eviction, what are some of the key takeaways from SB 567 so far? What are the biggest changes you're seeing in your practice?
Well, one of the most immediate changes is a much greater need for really detailed documentation. We have to be very careful about looking at the reasons landlords give for no-fault evictions, and we need to make absolutely sure they are following all the new requirements in SB 567.
I imagine that means a lot more investigation is needed now, and potentially challenging those claims in court.
Exactly. It's not enough to just take the landlord's word for it anymore. We have to dig deeper, request more evidence, and be ready to push back if we think the eviction is not justified, or if the landlord is not following the correct procedures.
So SB 567 is really raising the bar for legal scrutiny in these cases.
Definitely. And it's not just about scrutinizing the landlord's actions either. We also need to be proactive about telling our clients about their rights and options under this new law. For example, a lot of tenants don't know that they can ask for relocation assistance in no-fault eviction situations.
That's an important point. So let's talk about those relocation assistance provisions. What do tenants need to know? And how can attorneys effectively advocate for their clients when it comes to relocation assistance?
Well, the most important thing is to understand that relocation assistance isn't automatic. Tenants have to ask for it in writing, and the landlord is only required to provide assistance in certain situations.
What kind of situations are we talking about? How much assistance are landlords required to provide?
Well, that's where it can get tricky. It really depends on the details of each case. For instance, if the tenant is elderly or disabled or has children, the landlord might have to give more help. And the amount of assistance can be different depending on the local area and the tenant's situation.
So there's a lot of room for negotiation and strategy when it comes to relocation assistance.
Absolutely. That's where having a good tenant rights attorney can be so valuable. We can help tenants understand their rights, negotiate with the landlord, and if we need to, go to court to make sure they get all the assistance they're entitled to.
We've covered a lot so far, from the basics of no-fault evictions to the specific changes from SB 567. But I think it's important to take a step back and look at the bigger picture. We're talking about people's homes, their lives, their feeling of security. How do you see this law impacting tenant rights in California overall?
That's a really important question. I think SB 567 is a big step forward for protecting tenant rights. It shows that we recognize housing is a basic need, and tenants need to be protected from unfair evictions. But we also have to remember it's just one part of a much bigger challenge. There's still a lot more work to do to make sure all Californians have safe, affordable housing and that their rights are respected.
You're right. And that work requires us to be vigilant, to advocate for change, and to really understand this evolving legal landscape. So let's move on to the next stage of the eviction process now. Unlawful detainer lawsuits. What do tenants and their attorneys need to know about this part of the process? It seems pretty complicated.
Yeah, unlawful detainer lawsuits. That's where things can get pretty serious for tenants. Basically, it's when the landlord takes them to court to try to get them evicted.
So it's not just about sending those notices anymore. It's like a whole new level.
Right. And, tenants are already dealing with so much stress and uncertainty. It can be really scary to think about facing a lawsuit.
Our sources all say that ignoring an unlawful detainer lawsuit is like the worst thing a tenant can do.
It is. It's super important to understand that these lawsuits have very specific timelines and rules that have to be followed. If the tenant doesn't respond to that lawsuit on time, usually within 5 days, the landlord can actually get what's called a default judgment.
And so a default judgment means what? The tenant automatically loses?
Pretty much, yeah. That default judgment means the landlord has the right to evict the tenant, even if there are valid reasons why they shouldn't be evicted, or even if the whole thing was wrong in the first place.
Okay, so what should a tenant do if they get served with one of these unlawful detainer lawsuits? Like, what are the very first steps?
The most important thing is to talk to a lawyer right away. An attorney who knows about tenant rights can look at the situation, explain what the tenant's rights and options are, and help them through the legal stuff. It gets pretty complicated responding to these lawsuits.
It sounds like having a lawyer is absolutely critical at this stage. Can you talk more about how a lawyer can help? What are the specifics?
Well, a lawyer can make sure the tenant files their response to the lawsuit correctly and on time. That's the first thing, to stop that default judgment from happening. They can also investigate the landlord's claims, look for evidence, and figure out if there are any legal defenses the tenant could use.
Okay, what kind of defenses are we talking about in these cases?
Well, there are a bunch of possibilities. It all depends on the situation. Like, if the landlord messed up the process of serving the eviction notice, or if they didn't follow the rules in SB 567, that could be a reason to challenge the eviction.
So even if the eviction seems okay on the surface, there might be some kind of technicality or procedural error that can help the tenant.
Exactly. And a lawyer can help spot those things and build a strong argument to fight the eviction. Sometimes a lawyer can even work out a deal with the landlord so the tenant can stay in their home or at least get relocation assistance.
So even if it seems like a lost cause, it might not be.
Yeah, it's good to remember that every case is different.
Yeah.
And there's almost always a chance to find a way that works for everyone. But you really need a good lawyer to help you look at all the options and fight for what's best for the tenant.
Okay, so let's say the case actually goes to court. What happens then? What should tenants expect during a trial for an unlawful detainer case?
The trial itself can be super stressful. They have to show evidence, call witnesses, and make their case in front of a judge. Having a lawyer there to handle all that can make a world of difference.
I can imagine it would be really intimidating for a tenant to be in court, especially without a lawyer.
Definitely. A good lawyer can provide all that legal expertise, but also support them emotionally. Help them understand the process, get ready for court, and just feel more confident about dealing with the legal system.
So even if things don't go the way the tenant wants, having a lawyer can help make the whole experience a little less bad.
Yes. Absolutely. Even if the eviction is upheld, an attorney can try to minimize the damage, help make sure it doesn't hurt the tenant's chances of renting in the future. They can negotiate a fair move-out date and even try to get them some relocation assistance.
It really sounds like having a lawyer can be a game changer in these situations.
Yeah.
What are some of the big mistakes you see tenants making when they're dealing with these lawsuits?
One of the biggest ones is waiting too long to get legal help. People often try to do it themselves, thinking it will just go away, or they wait till the very last minute to call a lawyer. That really limits what can be done and makes it way harder to fight back.
So the sooner a tenant talks to a lawyer, the better.
Right. Exactly. The earlier, the better. That's how they have the best chance of a good outcome.
Are there other common mistakes people should try to avoid?
Yeah, another one is not keeping good records. Things like proof of rent payments, any conversations they had with the landlord, anything that could help support their case. Organized records can be really important.
It's not just knowing your rights, it's being able to prove them right.
Right. That's another area where a lawyer can be a huge help. They can tell tenants what kind of documents are important to keep, help them get organized, and make sure they're ready to present a really strong case in court.
So we've talked about how important legal representation is, keeping good records, and the different ways tenants can defend themselves in these lawsuits. But I think it's also important to remember the emotional side of things. Evictions are really tough for people to go through. What advice would you give to attorneys about how to support their clients through this?
It's so important to remember that these evictions are very personal and emotional for tenants. It's not just legal stuff. It's about losing their home, their community, everything that feels stable. As attorneys, we have to be sensitive to that.
It sounds like it's about more than just winning the case. It's about being there for the client during a really hard time.
Exactly. Clear communication is key. We need to explain things in a way that people can understand, keep them updated about what's happening with their case, and answer their questions. And just be there for them.
So it's about building that trust and relationship, making the client feel heard and understood, even though they're going through this stressful legal process.
Right. And it's also about being honest about what they can expect. We need to be upfront about the possible outcomes, but also let them know that we're going to fight hard for them and do everything we can to get the best possible result.
Okay, so we've talked about a lot. SB 567, unlawful detainer lawsuits, all the ins and outs. But you mentioned earlier how important it is to stay up to date with the law because it's always changing. How do you do that?
Well, SB 567 is fairly new. We're really just starting to see how it will be interpreted and used in the courts.
So, yeah, how can lawyers stay on top of all that? It seems like a lot to keep track of.
I think continuing education is key. Go to seminars, read legal journals, talk to other lawyers. Anything you can do to keep up with the latest cases, legal interpretations, and new trends in tenant law.
So be proactive, learn constantly, and adjust your strategy as the law changes.
Exactly. It's also really valuable to network and collaborate with other attorneys who do this kind of work. You can share experiences, talk about strategies, learn from each other's successes and mistakes.
It takes a community, huh?
Yeah, building a strong network of advocates is how we can make sure tenants all over California have the best legal help they can get.
I like that, a community of advocates. It reminds me that we're all working together, fighting for tenants' rights and trying to build a fairer housing system for everyone.
Definitely. And it's a fight worth having.
Well said. Okay, so as we wrap up our deep dive into no-fault evictions and unlawful detainer lawsuits, I want to leave our listeners with a final thought. This is just the start of the conversation. There's a lot more to explore and learn about all of this, but hopefully today has given you some good information to build on.
And remember, even though the law can be complicated and things can seem really difficult, there is always hope. There are people who want to help, resources out there, and ways to find solutions.
I think that's a good note to end on. So for all the attorneys out there, remember to stay informed, stay curious, and keep asking those questions. We'll catch you on the next deep dive. But for now, let's shift gears for a moment and talk about something that often comes up in these eviction cases, the issue of habitability. What are some of the common habitability problems that can lead to legal disputes between landlords and tenants? This deep dive has been really helpful. We've learned so much about no-fault evictions and unlawful detainer lawsuits in California. But before we go, I want to highlight some of the key points for our listeners, especially those of you working on tenant eviction cases.
Good idea. Let's go over some of the most important takeaways and things we can actually put into practice from our discussion today.
So first of all, SB 567 has really changed the game for no-fault evictions. It's given landlords new rules to follow, given tenants new rights, and given attorneys like us a lot of new things to think about.
You're right. We need to know that law inside and out. All the documentation requirements, the new definition of family member, and the right of tenants to move back in after renovations. We have to have a handle on all that.
And it's not just about knowing the law, right? We also have to think about how those rules will actually be used in the courts.
That's right. That's why it's so important to keep learning and keep up with new court decisions. We need to be paying attention to how SB 567 is working in real life, what arguments are being used, and what kind of precedents are being set.
It sounds like we're going to be busy with this law for a while.
Oh, for sure. But that's part of what makes this area of law so interesting, you know? It's always changing, always something new to learn.
So what advice would you give to attorneys who are just starting out with tenant eviction cases? How can they handle all this complexity?
I think the best thing is to never be afraid to ask questions. Reach out to other attorneys who have more experience, go to those seminars, join professional groups. There are so many people who are willing to share their knowledge.
Yeah, tap into that network of experts and learn from what others have been through.
Absolutely. And don't be afraid of the challenge. Tenant eviction law can be tough, emotionally draining, and intellectually demanding, sure. But it's also incredibly rewarding when you know you're making a real difference in people's lives.
You're fighting for their homes, their stability, their peace of mind.
That's it. And as the housing market gets more and more difficult, that work is becoming even more vital.
Okay, so as we wrap up our deep dive, I want to leave our listeners feeling empowered and hopeful. Even with all the complexities of the law and the challenges our clients face, we can make a real difference.
We have the skills, the knowledge, and the commitment to fight for what's right in the housing system. We should be proud of that.
Well said. Thank you for being here with me today. For all our listeners, remember to stay informed, stay involved, and keep fighting for tenants' rights. We'll see you next time.
Call now 714-442-9741. Thank you.